Hi, I'm attorney Jeremy Huss. When can the police conduct a traffic stop on a motor vehicle? The Fourth Amendment restricts law enforcement from conducting unreasonable searches or seizures. A traffic stop is a seizure. As such, the state may only conduct a traffic stop if it is reasonable. Now, what exactly does this mean? For purposes of a traffic stop or seizure, law enforcement must be able to articulate a reasonable suspicion. This means when asked, the law enforcement agent conducting the traffic stop can point to a specific, tangible reason that the traffic stop is proper. This would be a reasonable, articulable suspicion. A reasonable, articulable suspicion is not a high standard. It is not as high of a standard as probable cause, which means more likely than not. However, it is something more than a mere hunch, as a hunch cannot be articulated or explained through details. Most of the time, law enforcement can easily identify a traffic violation and can prove it with little issue. For example, a driver speeding, or weaving, or making too wide of a turn, or failing to use signals, or there are mechanical defects such as a head or tail lamp out. These situations are easy to prove and generally do not create issue for the state. However, issues can arise when law enforcement conducts traffic stops when there are no clear traffic violations. But officers articulate suspicious behavior due to the time of day or location of the vehicle. For example, a vehicle driving slowly through a known drug neighborhood at 2 a.m. may be enough reasonable suspicion articulated to justify a seizure or traffic stop of that vehicle. However, the same vehicle driving in that same neighborhood at 2 p.m. in the afternoon may not be enough to legally justify the traffic stop. Again, it comes down to the law enforcement agent's ability to articulate a specific, reasonable suspicion. In the first example, law enforcement may articulate the neighborhood is a well-known area for drug trafficking. The vehicle is driving slowly at 2 a.m. The second example is a little bit more difficult to articulate a reasonable suspicion. The only articulable fact is the vehicle is in a well-known drug neighborhood. Time of day is not as suspicious in this example. The driving slowly may still be articulated, but it will be more difficult for the state to justify the stop as reasonable under this scenario. However, it should be remembered that reasonable, articulable suspicion is not a high standard. Again, it merely requires the officer to articulate suspicious behavior. It should also be noted, law enforcement observation and perception may be in question due to vantage point or subjectiveness. Being able to identify a lack of reasonable articulable suspicion requires an experienced criminal attorney, well-versed in search and seizure law. Identifying and effectively framing this issue could be the difference between a conviction and a dismissal. Specifically, these issues should be timely raised in a pretrial motion to suppress. Anyone who has been the subject of a traffic stop and is now facing charges should call Huss Law today for a free consultation.